A patent grants an inventor a legally enforceable monopoly over their invention. This means that others can be legally restrained from exploiting the invention. There are two types of patents granted in Australia, a standard patent and an innovation patent. An Australian patent will only be granted for an invention that is novel. In other words, the invention must be new. Section 18 of the Patents Act 1990 provides that for an invention to be patentable under both types of patents, when compared with the prior art base as it existed before the priority date of that claim, the invention must be novel. The prior art base comprises of publicly available prior art information as it existed at the priority date of the relevant patent claim. This includes information that is made publicly available in a document or related series of documents, or through doing an act or a related series of acts, as well as information contained in a published patent application that has an earlier priority date than the application under examination. This means, before an invention can be deemed novel or new, publicly available documents must be assessed to determine whether the invention is unlike any other. If the invention has not been previously listed on any publicly available documents, it is likely to be deemed novel and can be patented. However, if the invention is similar to others that have been previously listed on public documents, it will not be novel and is unlikely to be patentable in that state. The priority date is the date at which the novelty of the invention is assessed against the prior art base. The assessment of novelty requires an investigation to establish whether the alleged invention has been anticipated by publicly available prior art information. Anticipation may principally occur through prior publication or prior use. The test applied to determine whether an invention is novel is known as the reverse infringement test. This test was set out in Myers and Vicar Industries as follows. The basic test for anticipation or want of novelty is the same as that for infringement, and generally one can properly ask oneself whether the alleged anticipation would, if the patent were valid, constitute an infringement. The court stated in the Apotex matter that the reverse infringement test is just one way of expressing the broader principle that, if a finding of anticipation is to be made, all that is essential to the invention must be read out of the prior publication. An inventor who discloses his or her invention to the public before the priority date will anticipate his or her invention, so the invention will lack novelty. In summary, novelty is a step towards patentability. For an invention to be novel, it must be compared with the prior art base that existed before the priority date. If this is fulfilled, the invention will be seen as new.